Welcome to the session on admissibility of digital evidence. After going through all the hard work for investigation of cybercrimes and collecting evidence and running so many phases and rushing in your investigation to finish the to help the investigation finished by also other investigators and in coordination with maybe other agencies. With all of these hard work, then you are expected to present your evidence that's admissible. That's the most important and crucial phase. Unless the evidence that you presented is not admitted, then your whole work is going to be wasted in the eyes of the criminal justice system. And this is important because the credibility of the digital evidence, if actually discussed and disapproved, then the credibility of the evidence and maybe the institution in terms of the investigating cases will be in jeopardy. So this is an important step for investigators to deal with. The objectives of this session include the review of the legal system in the United States and constitutional law in computer forensics and principles of search and seizure of computers and other digital devices and the rules for the admissibility of evidence at trial and review case law concerning the use of digital surveillance devices by law enforcement. The legal system in the United States is quite indeed complicated and is one of the most indeed complicated system in the world, primarily as a result of dual system that's comprised of federal and state laws and their respective court systems. So this is a quite a bit of challenge actually, as there are many countries in the world that only have a centralized system and a central legal system, and they do not have actually state laws as well as federal laws. So they have a unique system of laws, but the system in the United States is quite challenging to understand also and implement, as there are many laws that sometimes overlap, sometimes they have a little bit of a difference than the perception of the uh, federal system and also the state system, and the applications of law in different states vary. So this is quite a bit challenge for the United States law enforcement personnel, that they need to understand the complexity of the criminal justice system. And US legislation has been complicated further by growing importance of digital evidence in criminal investigations and trial proceedings. So this is another challenge for the law enforcement personnel in investigating digital evidence, as it's newly introduced the evidence to the traditional criminal justice system, and the actually legislation is or has been improving along the years, and maybe need to catch up with the new developments and challenges in terms of the cyber crimes. And US legislation at all levels has been impacted by computers and other digital devices, in which the system actually has to adapt itself to these new developments and challenges. Both federal and state laws actually impact criminal investigations and court trials, and investigations and court proceedings are actually influenced by the constitution as well, and constitution plays a significant significant role in terms of the investigation, as they limit the capacity of the investigation, which is obviously important for the freedom of the United States citizens. A computer forensics investigator must abide by federal and state laws when conducting an investigation, and it's important for them to have knowledge on both the federal law and as well as the state laws in the processing of the digital evidence. A case can be tried in several different ways. Actually, there could be a criminal investigation or a civil law suit that may change the nature of the investigation. In a criminal investigation, you will see a jury which might find the defendant not guilty, or in a civil law suit, you can see that there is a monetary issue and there needs to be a compensation given against the offender in the case. And in these lawsuits, or there is a plaintiff, which is the person who initiates the lawsuit and is responsible for the cost of the litigation. And also there is a defendant who is the person who defend himself in a given lawsuit. The United States Constitution was created in 1987, and it's a framework that defines the relationship between federal government and its United States and citizens. The first three articles of the Constitution establish the three branches of the government, the legislature and executive and the judicial branch of the governments are actually created through the first three articles of the Constitution. Another subject that needs to be understood in terms of understanding the origins of the US legal system are the ones that is found in common law and also in English law. The common law actually means that the decisions are actually based on case law and precedent with laws derived from the previous court decisions. With precedent, court decisions are binding on future decision in particular jurisdiction. So this means that a court gives a decision on a particular subject, but later it cannot change the decision or the decision made previously in the same jurisdiction. Therefore, these laws are derived not from legislation, but based on court decision. Civil law is based on scholarly research, which in turn becomes a legal code and is subsequently enacted by a legislature. So there's no precedent like it happens in the criminal law in the civil law. The structure of the US court system needs to be understood, as you will then have a better understanding of the rationale for cases being tried in federal court versus those cases tried in state court or country courts. A criminal prosecution might be tried in federal courts because of the obviously jurisdiction, meaning that crimes were committed across multiple states. Another reason for trying a case in federal court might be the nature of the crime. For example, the victim and the perpetrator could both be located in California, but the defendant was accused of corporate espionage, which threatens the national security and is therefore a federal case. Sometimes cases start in state courts, but the case is then referred to a federal district court. In the United States court system, the burden of proof is always on the prosecution. It's the prosecution who needs to collect all the evidence and claim that the person is indeed a real criminal. And the jury is actually to determine the facts of a case and render a verdict. The U.S. court system enables its citizens to appeal a conviction. An appeals court decides whether to hear an appeal. Note that a court appeal is not a trial. There's no jury, so panel judge renders a decision about whether a mistake occurred in a lower court. One example might be that evidence was presented at trial that should have been deemed inadmissible. The federal court system has three levels in the United System: district courts, circuit courts, which are the first level of appeal, and the Supreme Court, the final level of appeal in the federal system. The President of the United States is responsible for appointing federal judges, which includes the Supreme Court justices. The appointment is actually subject to the approval of the Senate. The judiciary branch is the ultimate arbiter of the law, not the Congress or the President. Federal courts are courts of limited jurisdiction, which means that they can only hear cases authorized by the United States Constitution or federal statutes. There are 13 circuit courts of appeals in the United States, and today there are 12 regional circuit courts in each several states, as well as an additional federal circuit court in Washington, D.C. Each of these circuits is assigned as circuit justice from the Supreme Court. Most federal cases start in a U.S. District Court. Cases in these courts can be civil or criminal. There are 94 U.S. District Courts across the United States, and every state has at least one district court, and larger states have more. The state court system varies from state to state. Nevertheless, there are some similarities. Local trial courts are located throughout the state and hear cases at the lower level. State appellate courts, often referred to as Supreme Courts or Courts of Appeal. These are the highest courts in the state's judicial system, and they often have discretion over which cases they hear and are often referred to cases where there could be an error in determining the law. Decisions from appellate court can be appealed to the state's highest court, which is referred to as the state appellate court. A trial by jury can be held in the following courts in New York City: Supreme Court, New York City Civil Court, and New York City Criminal Court. The following steps taken in the courtroom: first, jury selection, oath and preliminary instructions, opening statements, testimony of witness and presentation of other evidence, closing arguments, jury instructions, deliberations, verdict, and sentencing. The right to a trial by jury is clearly outlined in the Sixth Amendment of the U.S. Constitution. Voir dire is the questioning process used in the jury selection process. During voir dire, lawyers and in some cases the judge ask potential jurors questions to determine any prior knowledge of the facts of the case or any biases that could influence their impartiality in the case. All defendants are presumed innocent until proven guilty beyond a reasonable doubt. Jurors may be required to fill out a survey prior to oral questions. Civil trials typically have 6 jurors and up to 4 alternates. For criminal felony cases, there are 12 jurors and up to 6 alternatives. In lesser criminal trials, there may be six jurors and up to four alternates. During the trial, jury members may not discuss the trial among themselves or with others and may not read about the case. During a criminal trial, the prosecution makes an opening statement first because of the burden of proof is on the prosecution. Under the Fifth Amendment, the defendant needs not speak ever during the trial. Of course, in practice, defense counsel makes opening and closing remarks and is involved in direct examination, and also in cross-examination. Direct examination is the question of counsel's witness in a trial. A cross-examination is the questioning of two opposing sides' witness in a trial. Deliberations are the process whereby the jury reviews the evidence from the trial and discusses opinions about the case. A hung jury occurs when the jury cannot come to a unanimous decision in a criminal trial and a retrial must occur. Unlike a criminal trial, in a civil trial, the decision by the jury doesn't need to be unanimous. Criminal charges are initiated by government prosecutors on behalf of the people. As a result, the defendant is indicted to stand trial and answer questions relating to serious crimes or provide information. A felony is a serious crime and generally carries a penalty of a year or more in prison. Misdemeanor is a less serious crime as compared to felony and with a possible sentence of less than a year. In a civil trial, depositions may be taken, whereas in a criminal trial, they are generally not taken. A deposition is actually sworn witness testimony taken prior to a trial or, let's say, discovery, which can be presented during a civil trial. In a criminal trial, the standard to prove guilt is beyond a reasonable doubt. Beyond a, beyond a reasonable doubt means that regardless of the evidence, there must be no doubt in the minds of the jurors that the defendant is guilty. The judge is responsible for deciding whether the evidence being submitted is legally admissible. And evidence can include witness testimony. The admissibility of digital evidence is problematic as the judge and jury may not have any idea about what a system log is and whether it's acceptable in a court. The Bill of Rights is the first 10 amendments to the Constitution. It spells out Americans' rights in relation to their government. First Amendment provides freedom of religion, secures the freedom of religion, speech, and also press. And expression that is obscene is actually unprotected by the First Amendment. In Tinker versus Des Moines Independent Community School District, the Supreme Court ruled that public school officials cannot censor student expression unless they can reasonably forecast that the speech will substantially disrupt school activities or invade the rights of others. The decision firmly established that public school students possess First Amendment rights. Tinker remains the seminal decision on student speech, and wearing black armbands is protected by the First Amendment. First Amendment protects speech against government interferences. It includes the freedom of political protest, freedom of press, freedom to associate. Governments are able to restrict free express in some way, requiring a permit before a demonstration or prohibiting advocating criminal conduct. The Fourth Amendment protects individuals against unlawful search and seizure and provides a system of checks and balances in the judicial system. The Fourth Amendment is very important for the investigators to understand the limitations of criminal investigations, including digital forensics investigations. The Constitution, through the Fourth Amendment, protects people from unreasonable searches and seizures by the government. The Fourth Amendment, however, is not a guarantee against all searches and seizures, but only those that are deemed unreasonable under the law. A warrantless search of a private residence is a violation of a person's Fourth Amendment rights. The exclusionary rule states that evidence seized and examined without a warrant or in violation of individuals' constitutional rights will often be inadmissible as evidence in court in a criminal case. Fruit of the poisonous tree means that evidence that was initially acquired illegally, meaning that all evidence subsequently gathered at every point from the initial search is inadmissible in court. The Fourth Amendment is probably the most important part of the Constitution in terms of a computer forensic investigations and probably for all investigations. Law enforcement must obtain a warrant issued by a judge or magistrate before a search or arrest can be carried out. A search warrant is a court order issued by judge or magistrate authorizing law enforcement to search a person or place as well as seize items or information within the parameters of the warrant. Probable cause gives reasonable grounds for making a search, pressing a charge, and other actions that refers to the conditions under which law enforcement may obtain a warrant for a search or arrest when it's actually evident that the crime has been committed. Probable cause is actually related with evidence that gives someone a reason to think that a crime has been or is actually being committed. Law enforcement must show that a crime was committed, and that's more probable than not to expect that evidence exists at the place be searched. Normally, law prohibits the use of illegally obtained evidence in a criminal trial. But there is an exception to the exclusionary rule. United States versus Leon case, it was a United States Supreme Court case in which the court established the good faith exception to the Fourth Amendment's exclusionary rule. A judge issued a search warrant to the police in California. Later, the search warrant was found to be invalid because the police did not properly demonstrate the probable cause. Nonetheless, the police were deemed to be acting in good faith when seizing the evidence initially because they believed that the warrant to be valid at the time. The U.S. Supreme Court reversed and held that the exclusionary rule should be modified to allow the admission of evidence seized in reasonable good faith reliance on a search warrant, even if the warrant was subsequently found to be defective. The Court of Appeals held that although the government did violate Warshak's Fourth Amendment rights by compelling his internet service provider to turn over thousands of his emails content without a warrant, a reversal of his conviction is unwarranted as the agents relied on the Stored Communications Act in good faith. The Court of Appeals held the SCA unconstitutional to the extent it permitted the government to obtain such emails without a warrant. Because the agents indeed relied in good faith on provisions of the SCA, the exclusionary rule did not apply. Warrant is always specific to a particular crime in criminal investigation and is very specific to a geographic location. For example, if a house borders two counties, then the two separate warrants are necessary to search the entire property. So it is that specific and limited, and the search warrant needs to be addressing a particular crime in criminal investigation and to a geographic location. Search warrants are important steps of any criminal investigation, but not all searches require a search warrant. With the passing of the USA Patriot Act, law enforcement has been provided greater powers, which extends to warrantless search when a person's life or safety maybe is in danger. Exigent circumstances allow law enforcement personnel to conduct a warrantless search in an emergency situation when there is a risk of harm to an individual or when there is a risk of possible destruction of evidence. Another option for a warrantless search when it's appropriate if a consent is granted to a government agent, a warrant is not required. Consent can be granted when an individual waives his or her Fourth Amendment rights. However, this search is limited to the physical area of the individual authority and also is limited to a specific criminal investigation as in the nature of a search warrant. The individual giving the consent must be of some mind and must be an adult and must be educated with a certain degree of intelligence. Plain view allows a government agents to seize evidence without a warrant when the officer can clearly observe the contraband. To comply with this doctrine, an officer must be lawfully present in an area protected by the Fourth Amendment. The evidence must be in plain view, and the officer must immediately identify the item as contraband without further intrusion. In computer forensics, keyword search doesn't generally allow for plain view. While viewing the image to search for contraband materials, the investigator may unexpectedly encounter child pornography images that will allow you to seize the evidence. The investigator must stop the search and obtain new search warrant, as search warrants are specific to investigations. For example, police officer walk by your car, sees a package what appears to be crack cocaine based on her training. He can seize the cocaine and actually arrest you. GPS tracking is an important part of the police surveillance tactic. In 1980, Drug Enforcement Administration agents, having discovered that one carpenter had bought large quantities of chemicals and equipment used to make controlled substances, placed tracking devices in some of the equipment he purchased. Carpenter's truck led the agents to Defendant Ronald Dale Dunn's ranch. Aerial photographs of the ranch showed the truck backed up to a barn behind the ranch house. The ranch was completely encircled by a perimeter fence and contained several interior barbed wire fences. Without a warrant, officers crossed the perimeter fence. They were led there by the smell of chemicals and while they could hear a motor running inside. They didn't enter the barn but stopped at the locked gate and shined a flashlight inside, observing what they took to be a drug laboratory. They then left range, but entered it twice the next day to confirm the laboratory's presence. They obtained a search warrant and executed it, arresting Dunn and seizing chemicals and equipment, as well as bags of amphetamines they discovered in their house. At trial in federal district court, Dunn filed a motion to suppress all the evidence seized pursuant to the warrant. The district court denied the motion, and thereafter Dunn and Carpenter were convicted of conspiracy to manufacture controlled substances and related offenses. On Dunn's appeal, the appellate court reversed its conviction, finding that the evidence should have been suppressed because it was seized pursuant to the unlawful warrantless entry. The appellate court also found that the barn was within the protective ambit of the Fourth Amendment because it was within the curtilage of the residence. Later, the Supreme Court overturned the appeals court decision by finding that the barn was outside of the curtilage and all evidence obtained by the officers while standing outside the barn and looking in was admissible. Stingray is the generic name for an electronic surveillance tool that simulates a cell phone tower in order to force mobile phones and other devices to connect to it instead of to a legitimate cell phone tower. In doing so, the phone or other devices reveals information about itself and its users to the operator of the Stingray. Stingray help locate criminal suspects, but can also be used to locate people in disaster areas such as earthquakes. A pen register is an electronic device that captures the telephone numbers. Pen register orders require law enforcement to show only that information retrieved is likely to assist in an ongoing investigation. The use of GPS surveillance devices has clearly become a contentious issue, and there is a distinct lack of clarity in case law. The acquisition of digital evidence during a traffic stop can appear somewhat confusing when pursuing the case law. The New York prohibits the use of GPS tracking devices without a warrant. In the case of New York versus Weaver, a police officer attached a GPS device to a suspect's van bumper in connection with a series of burglaries. The defendant and the co-defendant were arrested and charged with burglary in the third degree and grand larceny in the second degree. According to the New York Court of Appeals, under our state constitution, in the absence of exigent circumstances, the installation and use of a GPS device to monitor an individual's whereabouts requires a warrant supported by probable cause. The acquisition of digital evidence during a traffic stop can appear somewhat confusing when pursuing case law. The defendant regarding New York versus Paris case was found guilty in Suffolk County Court, New York, of criminal possession of controlled substance in the first degree, false personation, and operating a motor vehicle while using a mobile phone, operating a motor vehicle without using a safety belt, and failing to stay in a designated uh, area or lane. Police stopped the defendant and impounded the vehicle in this case, and while the vehicle was impounded, an officer searched the vehicle and leafed through a notebook. The notebook indicated the possible presence of narcotics in the vehicle. Police then pried open a compartment and found bundles of secreted cash. With the car impounded, there was ample time for the law enforcement officials to secure a search warrant in order to make this significant intrusion. The defendant's statements were suppressed after the illegal search spread of the poisonous tree. The Fifth Amendment to the Constitution guarantees that an individual cannot be forced by the government to provide incriminating information about himself or herself, the so-called right to remain silent. When an individual takes the Fifth, she invokes the right and refuses to answer questions or provide information that indeed might incriminate her. The Fifth Amendment protects the individual from self-incrimination, and a defendant is not compelled to testify at trial and may plead the Fifth. However, an indictment is a charge delivered by a grand jury stating that the accused must stand trial, which is another issue in a court of law. The wording of the amendment, the Fifth Amendment, states that a defendant in a criminal investigation cannot be tried more than once for the same crime. Therefore, a computer forensics investigators must be sure that they have gathered all the necessary information and evidence before the case goes to trial. In the case of Miranda versus Arizona, the Supreme Court ruled that that an incriminating statement by a suspect is inadmissible in court if the suspect was not as advised on the Fifth Amendment right to remain silent and not give self-incriminating evidence. I'm sure many of you all already have heard the Fifth Amendment's statement given by the police. You have the right to remain silent. Anything you can say and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand the rights I have just read you? With these rights in mind, do you wish to speak to me? These are the statements that are given by the police before the arrest is made. Forcing the defendant to supply a password is forcing the defendant to provide testimony because the defendant is conveying his knowledge to access files with incriminating evidence. The Supreme Court broadened the right against self-incrimination to cover virtually all custodial police interrogations. The court established extremely specific procedural safeguards which must be followed during custodial police interrogations in order to avoid violation of the self-incrimination privilege. The Sixth Amendment guarantees the rights of criminal defendants, including the right to a public trial without unnecessary delay, the right to a lawyer, the right to an impartial jury, and the right to know who your accusers are and the nature of the charges and evidence against you. It's been most visibly tested in a series of cases involving terrorism, but much more often figures in cases that involve jury selection, for example, or the protection of witnesses, including victims of sex crimes, as well as witnesses in need of protection from retaliation. Congressional bills are legislative proposals from the House of Representatives and Senate within the United States Congress. Section 2511 of Title 18 prohibits the unauthorized interception, disclosure, and use of wire, oral, or electronic communications. Unless an interception is specifically authorized, it's impermissible and assuming existence of the requisite criminal event in violation of the Title 18 U.S.C. 2511. The law is clear in detailing how law enforcement is prohibited from using a wiretap without permission from a judge. In fact, law enforcement can be penalized for any unauthorized use of wiretap. A wiretap is authorized by Justice Department, signed off by a U.S. District Court or Court of Appeals judge, and is valid for up to 30 days. Under U.S. Code, under Title 18, service carriers may, on occasion, monitor and intercept communications to combat fraud and theft of service. The Federal Wiretap Act has been amended several times to account for changes in technology. The Electronic Communications Privacy Act of 1986 was developed to extend the restrictions placed on law enforcement by the Federal Wiretap Act. Basically, the ECPA extended the Wiretap Act to include electronic data transmitted by a computer from merely including the telephone intercepts. As part of the ECPA, Congress included the Stored Communications Act. When an individual uses an ISP or an electronic mail service provider, there are no protections under the Fourth Amendment. The Stored Communications Act was introduced indeed to protect the rights of the individual and maintain their expectation of privacy. The Stored Communications Act, enacted in 1986, provides statutory privacy protection for customers of New York service providers. The SCA controls how the government can access stored information from entities such as internet service providers. This information also typically includes email as well as subscriber and billing information. The Stored Communications Act was introduced to protect the rights of the individual and maintain their expectation of privacy. Stored communications is actually defined as any temporary intermediate storage of a viral or electronic communication incidental to the electronic transmission thereof, and any storage of such communication by an electronic communication service for purpose of backup protection of such communication. This act actually describes conditions under which a public ISP can voluntarily disclose customer communications or records. ISPs are forbidden to divulge to any person or entity the contents of any communication which is carried or maintained on that service. The Foreign Intelligence Surveillance Act outlines procedures by which electronic surveillance may be carried out to protect the United States against the international espionage by foreign governments. The act was subsequently amended by the USA Patriot Act in 2001, which extended the scope to include terrorism, which may not be state-sponsored. The Protect America Act of 2007 amended the FISA to allow for warrantless surveillance of foreign targets of intelligence gathering, which means that foreign targets can be under surveillance without a search warrant. This act was later repealed with the FISA Amendments Act of 2008. The Computer Fraud and Abuse Act was introduced to invoke stiffer penalties for those found guilty of unauthorized access to a network. Section 814 of the USA Patriot Act made several amendments to the Computer Fraud and Abuse Act, including an increase in the maximum penalty for hackers who damage protected computers from 10 years to 20 years in prison. Moreover, the act changed to include intent to damage a computer rather than simply a type of damage. The USA Patriot Act also included a new offense for damaging computers used for national security or criminal justice. The Computer Fraud and Abuse Act outlaws conduct that victimizes computer systems. It's indeed a cybersecurity law, and it protects federal computers, bank computers, and computers connected to the internet. Communications Assistance for Law Enforcement Act introduced to facilitate law enforcement in their surveillance activities of companies. Telecommunications companies were forced to redesign much of their infrastructure by or to become compliant with this act and provide improved electronic surveillance for law enforcement. The USA Patriot Act was introduced in the wake of September 11 attacks to provide greater powers to law enforcement in an effort to prevent terrorist attacks from happening again. This act actually has impacted investigations involving digital forensics as well. For example, if law enforcement received an email from someone who had been kidnapped, then under the USA Patriot Act, law enforcement could act without the use of a warrant because someone's life is in danger. On Section 202 of the USA Patriot Act, this act provides law enforcement with the authority to intercept voice communications in computer hacking investigations. Previously, law enforcement couldn't apply for a wiretap order or wire intercept for violations for the Computer Fraud and Abuse Act. So this act gave more opportunities for the law enforcement to track down the violations regarding the intercept or wiretap order as needed. Section 209 impacts law enforcement's access to electronically stored voice messages like voicemail. Since the Electronic Communications Privacy Act, changes have been made to the electronic storage of communications. Section 209 now allows law enforcement to access stored voice recordings without a Title III wiretap. Procedural remedies and other tools to end the exploitation of children today Act of 2003 was introduced to provide greater protection for children against abuse. The law eliminates waiting periods for law enforcement to begin investigating missing persons between the age of 18 and 21. Another provision of the Act is the elimination of the statute of limitations for child abuse or kidnapping. The Act also prohibits computer-generated child pornography, although the First Amendment constitutionally actually of this provision has been questioned in case law. Rules of evidence determine what types of evidence is admissible, and the trial court judge applies these rules to the case. Generally, to be admissible, the evidence must be relevant and not outweighed by countervailing considerations. Rules for evidence admissibility can be broken down to several admissibility of rules actually that includes Frye test for evidence admissibility, Daubert's test for evidence admissibility, federal rules of evidence, expert witnesses are also included, and federal rules of evidence and hearsay, and best evidence rule. Traditional evidence is gathered from a crime scene or suspect and remains unchanged when admitted to court. In digital forensics, systems are often in a state of flux. For example, if a system is running, then the contents of RAM are particularly important in potentially finding a suspect's password. Websites visited, processes running, and so forth is actually very fragile to recover. Nevertheless, while gathering the contents of the RAM, the computer's memory is continually changing. And these continual changes makes things more complicated, and these continual changes make the evidence easier to challenge in court. When dealing with the issue of admissibility in court, we rely on case law, especially as it relates to acceptable scientific principles or scientific practice and what are known as evidence admissibility in terms of federal rules of evidence. A court applying the Frye standard must determine whether the method by which that evidence was obtained was generally accepted by experts in the particular field in which it belongs. The Frye standard has been abandoned by many states, and the federal courts are now in favor of the Daubert standard, but it's still law in some states. Under the Daubert standard, the factors that may be considered in determining whether the methodology is valid are whether the theory or technique is in question can be and has been tested, whether it's been subjected to peer review and publication, and whether it's known or potential error rate, and the existence and maintenance of standards controlling its operation, and whether it has attracted widespread acceptance within a relevant community. So these standards are more elaborative and more consistent with the current developments in science and scientific procedures. Federal rules of evidence actually sets the standards that determine the admissibility of evidence in both civil and criminal cases in federal court. Nevertheless, many states have adopted similar guidelines for evidence admissibility. The federal rules of evidence are indeed a set of rules that actually governs the introduction of evidence at civil and criminal trials in the United States federal trial courts. The current rules were initially passed by Congress in 1975 after several years of drafting by the Supreme Court. The rules are straightforward and relatively short compared to other sets of court rules, such as the Federal Rules of Civil Procedure. The federal rules of evidence are broken down into 11 articles that include general provisions, judicial notice, presumptions in civil actions and proceedings, relevancy and its limits, privileged witnesses, opinions on expert testimony, and hearsay, and so forth. Hearsay is an out-of-court statement offered to prove the truth of whatever it asserts. Hearsay evidence is often inadmissible at trial. However, many exclusions and exceptions exist. The testimony that's not first-hand is referred to as hearsay and is therefore inadmissible in court, but an exception to hearsay exists regarding digital evidence under the federal rules of evidence. Expert testimony can be divided to expert testimony can be provided during a trial or in a deposition. A deposition is a pre-trial testimony given under oath with both defense and prosecution attorneys present. Both the defense and the prosecution can use their own expert witness and have the right to cross-examine the opponent. Expert witnesses may also be appointed by the court. The role of the expert witness is to protect the jury. Unlike lay witnesses, an expert witness can express opinion according to the Federal Rules of Evidence 704. Federal Rules of Civil Procedure 2682 governs disclosure of expert testimony. The rule purports to create a clear delineation between experts that must provide a written report and those that do not. The rule then outlines the disclosure requirements that must be satisfied as to each type of expert. Under the Rule 26(2)(b), the expert witnesses written report must contain the following: a complete statement of all opinions the witness will express, and the basis and the reason for them obviously are important. The reasoning behind the report is essential to explain that the indicted is indeed responsible from the actions she performed, and the facts or data considered by the witness informing them, and any exhibits that will be used to summarize or support them. So exhibits are very useful for actually shaping or for explaining the criminal events or the matters that's related with the cyber forensic investigations, and the witnesses' qualifications, including a list of all publications authored in the previous 10 years, maybe, and a list of all other cases in which during the previous 4 years, and a statement of the compensation to be paid for the study and testimony in the case. And in summary, we have reviewed several issues related with the structure of the legal system in the United States, the role of the constitutional law in computer forensics, and principles of search and seizure of computers and other digital devices, and rules for admissibility of evidence at trial, and many others. And in the next lesson, we will cover network forensics and incident response. Thank you all for listening.